ahead and call the Board for Licensing Contractors meeting. Call to my left.
Ernest Owens,
Marvin Sandrell, Columbia, Tennessee.
Cindy DeBus, Knoxville, Tennessee.
Bill Mason, Greenbrier.
Mark Brudd, Knoxville.
Jerry Hayes, Paris.
Keith Whittington, Johnson City.
Reese Smith, Franklin.
Ronnie Tickle, Memphis.
Okay. First order of business is to adopt our agenda. Are there any?
Adopt the agenda.
Second.
All in favor, say aye.
Aye.
Any opposed? All right, we've adopted the agenda.
Approve the hardships that were approved by the executive director.
Second.
Any discussion? All those in favor of the motion, say aye.
Aye.
Any opposed? That motion carries. Item on the agenda was the board meeting transcript from March 25th.
Move to approve.
Second.
Any other discussion? Aye.
Aye.
Any opposed? Motion carries. Need the same for the May 22nd. Discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. Waived ones first. Take a motion.
Move to approve with any notes by the individual board members.
Is there a second? Discussion? All in favor of approving the waived applicants as noted by Bill, say aye.
Aye.
Any opposed? That motion carried. Reviewed applicants. Do you have any discussion on interview?
Top Notch Construction. Interviewed him. He's a young man. License. He had a felony in 2005. The felony was he started to make meth and he was caught. Went to jail for a year, and then from there he went to Teen Challenge. Life around, became a counselor. He continues to work for them as well as and like I said, very nice. He's married, has 3 children, and I'd make a motion that we approve him.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Top Notch is approved.
Thank you.
I've got one also. His name's William Osmond. He's doing business, Osmond's Handyman Repair, or he's wanting a license, wanting a home improvement license. He's had some felonies. One of them was attempted murder. He spent, I think, these, but I've also found 2 more. I found one here, theft of property, 1,000 to 10,000. I found another one here, vandalism, of 10,000 to 60,000. And he's on parole right now. So,
Think you need,
road for another, to
hey,
17.
what is your recommendation?
I recommend we can't give him no license.
I
Just wanted to bring it up.
Is there any other discussion on Osborne? All in favor of not
Mark,
granting?
the public, there's somebody out in front.
Are you still on parole?
That's what I started to ask.
Yes, sir, till 2016.
Policy not to give licenses to anybody that's still on parole.
Oh, I mean, he could, work for somebody else, but I don't think we can give him a license till he gets off parole.
Prevent you from working for somebody else.
Appreciate you turning your life around and all that, but right now, until you get off parole, we really can't do anything on that aspect.
Well, you were welcome to make an application, but the board has the responsibility to make a decision on whether we're going to approve it or not, and that's what we're about to do. So, I mean, I don't think we're obliged to, I understand your dilemma, but I don't think the board's obliged to refund you those things.
Like you could get, I mean, you pay for your license up front for 2 years, and he didn't get a license.
You should get a refund of that part.
Refund on the
Yeah, he can-
license.
Yeah, he can get a refund of the home improvement fee.
But not the application fee.
Application fee, yeah, he can get a refund for that.
He
Okay.
can get a refund?
Just for what he did for the board, not for the bond or the insurance.
Right.
Right.
But yeah, we can refund the $250 application fee.
Oh, well, that's
Okay.
good to hear. I'm glad to hear.
Anything that you gave this board right here, we can help you out. Yeah, you might want to wait till after this is over with and then see somebody who they need.
I'll take care of it after the meeting. I'm going to get the refund today. We put the request in after the meeting, and then it'll be about 6 to 8 weeks. They'll
You don't have to come back.
You're going to do it for him. I mean, you're going to automatically do that.
Right, I'm going to do it for you.
Thank you.
All in favor of the motion that's on the floor, say aye.
Aye.
Any opposed? The motion carries that the license is not granted for Osborne. Any other interviewed?
Mr. Chairman, I've interviewed a couple that I need to bring before the board. One is a HRA contractor out of Texas. He's also licensed in Louisiana and Oklahoma. He came into Tennessee and admitted to bidding a Walmart parking lot to apply the asphalt, and subsequently claimed that his CPA told him he didn't need a state contractor's license. So he bid the job. He did not start the job. In fact, the job doesn't start until September. So given that fact, I recommended to go ahead and issue the license for the monetary amount of $1,500,000, but to issue a $1,000 civil penalty for bidding without a license in the state. And I make that a motion. The license number is 67990.
How much was the contract?
Don't know how much the contract was. Well, I said the amount that they had applied for was $1,500,000.
Okay.
Looking at some of the work that he claims to have done, 2014, and 2013, it could have been $500,000. It looks like he's listed parking lot and repairs, parking lot repairs, and I don't know if that's, it appears to be different locations, but I don't know if it's multiple parking lots in the same city or if that's.
You think that's enough, $1,000?
I felt like it was because interviewing the applicant, he seemed to be truthful, and he had already had some harsh words with his CPA. The company's large enough and does enough volume that he did rely on his CPA for his information, and I think the CPA subsequently has lost his employment position with the company, so I felt like he was honest enough to make it no harsher than that.
These other projects, Keith, are they?
No, they were in Texas, Oklahoma.
So only one job that he's bid, but not. That's in the form of a motion, I guess, for his approval with a $1,000 fine. Is there a second?
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries.
The second one I have is a home improvement license application. It's 7746, I assume is the number on it. The applicant was asked to appear before the board because he had a felony record that was a pretty good felony record. I didn't even really get into that portion of it. I got into the part of the application where he had applied his experience, and the first one was a roofing job, and I asked him exactly what he did on the roofing, and he said he didn't do anything, that he had other people that done that for him. And I said, do you know how to do roofing? No, I do not. And then the second item, likewise, was a different, it was painting and landscaping, and he had other people that he worked with that performed that work. He didn't actually do it. Then he listed an HVAC project for $1,000, and I said, well, what do you know about HVAC? And he said, absolutely nothing. And then I just told him that based upon his experience, I wouldn't even consider whether or not he had a criminal past, but his experience disqualified him for issuing a license. So that's my recommendation is 7746 be denied.
Further discussion? All right, all in favor? Carries.
Chairman, I have three. Are you through, Keith? Sorry.
Yes.
Brooks Roofing and Siding, a home improvement, had an unlicensed activity in Davidson County. He'd done a lot of other work in other counties, but all of them were okay. He had acted on his attorney's advice and apparently was misunderstood. He did go to the website and look to see if he was supposed to have it, and he didn't look in the right place, but he admits that he did that one job, and I recommended that we approve it with a $250 civil penalty. On Eldridge Wayne King, he had a complaint from a disgruntled customer, but he did do, he went over his limit on that job and admits that he did that, and I recommended also that we approve it with a $250 civil penalty. And then on DeGuaro and Sons, there was a felony for the qualifying agent. They were going to add class for CE. He's been off probation for 10 years, and the employer came in with him and impressed me that there was no reason not to allow that add class, and recommend that one be approved. So I move those three as I have described them.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
I have one.
Okay.
Spent most of the morning with, finally called the chairman in. This is KASAA, CASA, Building Systems and Construction. They've come into the state and have two jobs in West Tennessee. One's a $6 million grain bin, the other one's a $2 million grain bin. They are 40% complete with one, 60 complete with the other. They're sort of specialized grain bins, if there is such a thing. They have now come to get a license. And Mark and I told them that they also have negative working capital, and they need an unlimited license. Owner would be have a real problem if we stopped the job today. We told him that we would bring it to the board, that he could continue to work for 30 days, and he had to have all of his everything involved with getting a license satisfied by September 1st, or he'd have to shut the job down. We agreed that he would be fined $10,000, $5,000 for each job, no matter what, and then he would be fined $5,000 a day after September 1st if he continued to work. I think that's the way I understood it. They have passed the industrial exam. I would move for approval for KASAA, CASA.
Second.
Ernest.
Just on those two jobs? you
Just
had-
on those two jobs. He can do no more work in Tennessee.
I have a question.
Approval is contingent upon him submitting proper
Person that he's working for, are we going to notify them as to the condition of the person that's working for him? That's pretty,
Well, he knows it, and he's really going to know it by this time tomorrow when he has to go to him and tell him that he's going to ask the owner to indemnify him.
okay,
The owner's a big commercial outfit.
okay.
Yes, they are.
I didn't want that.
And he'll have the $10,000 paid before September 1st? Is that part of the contingency?
I'm not sure we put a time limit on that.
I think that.
But he would have to, in order to get a license, he's going to have his,
Have it paid?
oh, absolutely.
Okay.
All right, that was a motion by Reese. Who was the second by? Or do we have a second? Other discussion? All in favor, say aye.
Aye.
Any opposed?
Abstain.
One was a monument builder that has been in business over 100 years. License now. He did bid the $50,000. Improvement contractor, didn't know he had to have a license to do, he does window installation. He needs a home improvement license if he has contracts over $3,000.
Hey, you didn't find him nothing in the monument building?
Business for such a long time, never had to have a license because they do small monument work. This one at 50 and one other that he did, like,
On Birchell, how many jobs over did he do that? I'm kind of like Marvin a little bit, you know. I have these guys come in and interview. I'm convinced they didn't know, but I always use the analogy in ignorance of the law. We require people to have a license to do certain kinds of work at a certain level, and most cases like that, I think in two I already did today, I came up with just the minimum fine, which was $250. Like that, you kind of ought to hold, if you don't hold people accountable when they fast lane, then even if they don't mean to, ought to have been maybe at least a minimum fine on the monument maker.
Did that include installation, that 50?
Yes.
Probably.
monuments are decoration, I guess. They're essentially.
There's a lot of cemetery monuments. That might be what this is. Both whatever the chairman says.
You made the interview, and I don't want to overrule, and you've already let the guy leave with that understanding.
Yeah, that's the only.
Well, it is on you. It's not
Business.
like putting a roof on or you know, building a garage or something. I agree it's a different kind of a thing, and I certainly won't vote against your motion, but I do think that we violation, it's ought to be very rare that we, and this is a rare case, and I I'll second your motion.
Okay?
Both of them.
Installer and the monument builder. Any other discussion? Got all the interviewed applicants, or do we need a general one for the ones we haven't brought?
I make a motion that we approve or disapprove accordingly to however a board member may have ruled on an applicant that we may have missed.
Okay, is there a second? Say aye.
Aye.
Any opposed? That motion carries. Revisions. Need a motion. Second? Any other discussion on revisions? Aye.
Aye.
Any opposed? Motion carries. Licensed electrical applicants.
I'd like to make a motion to
Second. Any other discussion? Aye.
Aye.
Any opposed? Motion carries. Our agenda is David Witt with the board mission. The legal report, Benton.
Thank you, Mr. Chairman. The first matter to be discussed in this legal report would be the first two complaints, case number 2014002161 and 2014002162. In that matter, I initially recommended a consent order with a $500 civil penalty and authorization for a hearing. And at this time, though, that's been changed to close that case, those two cases in this matter. And then the next one, the number 9. 9 is case 2014003301. In that case, it was recommended that a consent order with a $1,000 civil penalty and authorization for a hearing be assessed. And that has since been changed to closure of that case as well. Next is number 12. That's case 2014003761. There was an initial assessment of a consent order with a $5,000 civil penalty and authorization for a hearing, and that has since been recommended to a $500 civil penalty along with consent order and authorization for a hearing in that case. The next one would be number 13 and number 14. Those are case numbers 2014003811 and 2014003812. In this case, it was initially recommended that these two cases be dismissed. However, it's since been recommended that both of these cases be closed and flagged. Next one is number 18, and that involved case number 2014005211, as well as case number 2014005212. Our initial recommendation in that case was for a consent order with a $5,000 civil penalty and authorization for a hearing, and that has since been changed to a consent order with a $1,000 civil penalty and authorization for a hearing. Next is number 23, 24, and number 25, encompassing case numbers 2014-002291, 2014-002292, and 2014-002293. Initially, the recommendation was for the members to discuss this case, and it has since been recommended that these three cases be dismissed. Next would be case numbers 38 and 39, which would be complaint number 2014-003921 and case number 2014-003922. This matter was also, it was recommended that these cases be discussed, and it's now being recommended that in case number 38, that case be dismissed, and case number 39, that there be a consent order with a $10,000 civil penalty and authorization for a hearing to be assessed in that case. And next would be case number 45 and 46, which includes case numbers 2014-004971 and 2014-004972. It was initially recommended that we assess a civil penalty, a consent order with a civil penalty of $1,000 and authorization for a hearing, and that has since been changed to a recommendation of consent order with a $5,000 civil penalty and authorization for a hearing in those two cases. Next would be cases 48, 49, 50, 51, and 52. It's case number 2014-005131, 2014-005132, 2014-005133, 2014-005134, and 2014-005135. Initially, we recommended a consent order with a $1,000 civil penalty and authorization for a hearing, and we are now recommending a consent order with a $2,000 civil penalty and authorization for a hearing in that case. Next would be case 54 and 55, encompassing case numbers 2014-005621 and 2014-005622. The initial recommendation in this case was for the members to discuss that, and the new recommendation is that these cases be closed and flagged. Next would be number 56, which is case number 2014-013971. This was initially recommended that a consent order with a $5,000 civil penalty and authorization for a hearing be assessed in this case, and the members decided that litigation monitoring consent order would be better in this case due to the matter being in litigation currently. Next case would include number 58 and 59, which would include case numbers 2014-002281 and 2014-002282. Initially, we recommended that a consent order with a $5,000 civil penalty and authorization for a hearing be assessed in this case. At this time, though, we found that more information was necessary, and so this case will be held back until the next board meeting. The next one is case number 60, which is case number 2014-003741. Initially, it was a recommendation to discuss this matter. Now we're recommending a $5,000 consent order with a $5,000 civil penalty and authorization for a hearing for unlicensed contracting on behalf of the entity involved. Also, consent order with a $5,000 civil penalty and authorization for a hearing for poor workmanship from the contractor. And then also a consent order with a $5,000 civil penalty and authorization for a hearing due to unlicensed contracting on the part of the individual in this case. Next is number 61, which is 2014-005061. We initially recommended that this case be dismissed, but the new recommendation is for a letter of warning in this case. Number 62, is case 2014005481. Again, this matter was recommended for dismissal. However, the new recommendation is for a letter of warning in this case. Number 63 is 2014005861. In this matter, we initially recommended that this matter be dismissed as we felt that there was no evidence presented to support the allegations. However, we did receive additional information yesterday, and in this case, we found that the respondent did provide invoices showing that they twice exceeded the $25,000 limit prior to obtaining their contractor's license on March 26 of 2014, and therefore we're recommending a consent order with a $5,000 civil penalty and authorization for a hearing in this case. Number 65 is case 2014003751. Initially, we recommended that this case be discussed with the idea that a consent order with a $2,500 civil penalty and authorization for a hearing be assessed due to a violation of Tennessee Code 62-6-119, which encompasses the bidding statute. And we're now recommending in this case that that this matter be closed and a letter of warning be sent to the architect with a copy of that being sent to the architectural and engineering board to make them aware of the letter of warning. And we also had an addendum that that was presented as well. In this matter, there was a represent that starts on page 1 and ends at the top of page 2. I'm sorry. It starts at the bottom of page 2 and ends at the top of page 3. And in this matter, was initially recommended that this matter be closed due to the fact that the complainant had passed away in this matter and could therefore no longer testify. However, at this point, we're now recommending that the board pursue the $2,000 civil penalty that was assessed originally in this case, and there was some additional information that the respondent was supposed to provide along with that initial consent order that was sent earlier, and therefore we're now recommending that instead of closure, that this case be pursued and that the council pursue the $2,000 civil penalty as well as the the additional information that was supposed to be provided initially in that case. And then I believe that concludes my legal report. However, I know that Ms. Lazenby had one matter that she wanted to make the board aware of as well.
We've received a bid protest by a housing agency, and they have requested assistance from the board with moving forward in awarding the contracts for 2 duplexes to the low bidding contractor. Allegation from the second low bidder was that the contractor exceeded their monetary limit more than the 10% allowed. 4 bids were received, 3 were combined, and 1 was separate for each duplex. Each duplex is on a separate lot and has a separate address. And the housing agency provided a copy of the lots on the map. They also provided a letter stating that separate contracts will be issued for each duplex. And we are asking, I had the residential subcommittee looked at this, and it was their recommendation that the contractor did not exceed his monetary limit and that it was okay to move forward with awarding the bid.
Was there a possibility that different contractors could have gotten different duplexes?
O's.
So they were separately bid out. Wasn't a guarantee that one contractor would get all of the jobs.
Individually.
The other ones combined, like, combine two, and if you combine two, then you were over your limit. Catch of it is the municipality said they didn't specify doing it together or individually. The man that did it individually did it the way that the municipality really wanted it done. That's correct.
To the microphone, please.
When we had the bid proposal, when everybody met today to go over.
Could you say who you are, sir?
My name is Jerry Oliver with Southwest Human Resources out of Henderson, Tennessee. And they were all aware that they bid on one house, they get 2 duplexes. There were some changes in the duplexes. We just wanted to make sure one contractor, whoever had the lowest bid, got both houses. All our intentions were all along. There was contract on each duplex, because there's 3 different lots, 3 different addresses. I give each one of them the what it would cost to do the utilities per lot, per house. So that was our intention to do.
So is the intention to each job separately?
Yes, sir.
So there was a possibility that one contractor could have gotten one of the duplexes and another could have gotten the other.
They could have. Okay.
It could have happened that way.
They could have
All right,
happened
that's
that
what that's important to me.
Yeah.
I thought you just said that.
But due to our way our plans were, there's going to be a change in them, and so we just asked whichever one of them got the lowest bid would give them the other one.
It's a whole different ball game.
It's different.
Whole different ballgame. That's what that's not what we interpreted just a little while ago.
Well,
So what you just said is completely different
All right.
than how we have interpreted it.
Okay.
I will say that right now. So our recommendation, Carolyn, to you is wrong.
Okay.
But that's all we wanted to do. We just wanted to make sure we were right. I mean, we did it right because there were some changes, and we just wanted to make sure whoever got the low bid got the other house too. But there was all going to be different contracts, different lots, and all that.
Correct, but that's not, the
We
way
told
we
them on
had
the
it just a
front
little
end.
while ago, that's not what we thought it was. We thought it was individual, but when you combine two, it throws him over his limit, and therefore, the man that got the job, he is really disqualified.
That's right.
In my opinion.
So it was going to be 2 different lots, things, okay.
Correct.
Where we wanted to know, you know.
That's why I asked the question, if there was a possibility that the 2 different lots could have gone to 2 different contractors.
No.
And
But
you're
we-
telling me that there really wasn't that possibility, that you intended for them both to go together.
That's what we wanted, okay.
That's what you wanted, but was that a requirement?
Let me go back again. When I sat down when we all met, okay, then we told them that, you know, we had some changes in the floor plans, okay, and that we wanted to bid on one duplex, okay, and whoever got that duplex is a possibility to get the other one.
Possibility.
Yeah, that's what we wanted, and there was going to be 3 contracts, 3 different lots, 3 addresses, and all. But that was our intent. If we broke the law, we didn't do it.
Separate contracts for each building site?
That was our intention. It's gonna be there's 3 different lots, it's gonna be 3 different houses, okay? 2 duplexes and a house.
Was the plan to award both buildings to the same contractor? Immediately? The winning
When I
bid
did
got...
one of them, we were gonna do one contractor, and another contractor, the other one. That was our intention. But it's kinda got blown out of control, so I'm at y'all's mercy.
Well, the question I'm asking is, was the plan to sign both contracts immediately?
We were gonna do one and start one duplex, then whoever the other contractor was gonna start the house. Then when they got them going, then we would get the other one.
There were 3 bids, right? 3 different bids?
3 different-
I mean, 3 different buildings.
Different lots, 3 different houses.
You didn't make 3 separate bids, it was one bid.
No, that was 3 bids. There was 2 bids. There was a bid for a duplex and a bid for a house, okay? That's the way we bid it out.
Okay.
Then,
The house is separate, we get
House
that
is separate.
part.
It has nothing to
But
do
the
with the
duplexes
duplexes.
were bid as one bid,
It's bid is
at a per piece.
at a per piece.
The contractor got that and to get all the rest of it.
I think he's on 3 different plots, 3 different tax bills, 3 different
Why wouldn't they bid the next to that?
meters. Oh, that's not really our problem, but.
It is, because that's why it's been challenged. That's why he's up here. Because he's been, low bidder
Right.
has been challenged, and it's been challenged because
Did
the,
he give you 3 separate numbers? One for each lot?
Give me 3 of the contractors gave me one full price for both duplexes, okay? What I didn't ask for in the first place. I asked for one. Then one guy gave me one, for that one duplex, plus a house, okay?
Gave you 2, one for the house and one for the duplex.
Right.
And after you got the duplex, you said, we're gonna give you this other duplex because you got this one.
Right.
I really don't have a problem.
What you just last said, I think the guy's legal on 3 different parcels
I-
of land, 3 different sets of meters,
See,
3
then
different
they
tax
got all
bills,
that, it's all in the
3 different
paperwork there.
building permits, correct?
Yes, sir. 3 everything.
Seemed like 3 other contractors bid the whole thing, and this guy just bid.
I just told them, when we had the pre-bid thing, I just told them that's where I wanted it bid, but they put it together. But I don't know,
you have 3 bid packages.
we only had 2 bid packages.
Okay.
House and,
And when he won the duplex, then you gave him the other duplex. So you didn't bid out that other duplex.
it's bid one duplex.
Yeah. He should have bid the other duplex separately.
That's what throws you over.
I think so too.
That's why you're over when you do.
Well, I'm at y'all's mercy. I was always under the impression that if you had 3 different lots, and 3 different things, that you was okay, but if you bid it all on one, if it was on one piece of property, then you, sure enough, he's over.
Jerry used to work for us. Jerry used to be one of our inspectors / investigators / auxiliary board member. But that's the way I always heard it too. You got 3 different sites.
That's what I did, that's what I was
They just
doing.
happen to be in the same neighborhood, but.
Yeah.
Well, if he'd taken 3 different bid packages, he'd be fine. But he didn't take 3 bid packages. He took just 1 bid packages for both the projects, and then he just doubled the price and gave this contractor both
He gave it, yeah.
places. So, but then I guess the question is, it seems like in this public housing, he'd be required to take bids for each project, which he didn't do.
Exactly.
He didn't take bids
You'll
for
just
each
give him a
project.
second one to him. Should have bid it separate.
Yeah, you should have taken 3 bid packages. And that's where the problem is. I'm not sure as involved as y'all are for not bidding this correctly.
Who's the owner?
Southwest Human Resources out of Henderson.
Public housing.
It's like,
It's not
y'all have-
owned by
what
the
y'all have up
city.
here, Upper Common or something like that?
It's a community development
Okay.
corporation, correct?
I got you.
Handicap stuff.
If you take one of these over the other, is that gonna cost you a lot of money?
Yeah.
About 10,000.
$10,000?
Cost a minute. Then therein lies another problem that y'all can help with, okay? Is if we have to take the next bid, then we haven't done any reference things on him. So if his reference turns out bad, do we have a problem?
I think we ought to require them to rebid both of those duplex projects.
We don't have any problem doing it.
Something that we have saying that if the one that bid it wrong, the one ain't bid again.
I don't know that he bid wrong. I think his issuance of the bid was wrong.
I think it was a
Really bid over his
misunderstanding of the
license.
orders in the bid that created the whole issue.
Therefore, we
And
would have
apparently
to,
3 heard it one way and
Some
or
heard
read
the
it
other
one
way.
way and one read it the other.
Right.
And they bid it improperly according to what they read. And based on what he's told us, based on the fact that we've got the intention was 3 different permits, 3 different sites. I'm with Reese. That makes of them 3 separate projects. Had they pulled
3 different contracts, right?
Had they pulled 3 or 1 permit, or in this case, 1 for the house and 2 for the duplexes, which I don't think a
that's
city would
normal.
write a permit that
That's
way
normal,
anyway.
but this wouldn't have laid out that way.
But if they didn't take but 2 bid packages, one for the house, one for one of the duplexes.
Right.
And then when he got the one duplex, they just gave him the other.
Gave him the other one.
Well, that's where the problem is.
Over his
right,
limit.
but we're gonna end up
why is
having to
that
make some kind of decision to cover everything on the gentleman that we're gonna jerk the bid away from, to be able to come back and bid again, because it's not gonna be fair to him.
I agree. I don't think it'd be fair to him to take it.
Why is that a problem if I was awarded the duplex and the house, and my price was so good on the duplex, I'm gonna go down the road and give you another one?
Well, if I were a private owner, it wouldn't be a problem. But on these
not
Community
our-
Development Corporation is really not so much public. It's kind of a private entity
It's
that
kind of a
relies
private deal, but, you know,
on grants.
yeah, we do basically.
And they repay the grants as they reinvest in the community and make a profit off the various properties that they sell. Some they choose to keep in their portfolio and operate as rental property, and some they either build from scratch or renovate and put back out on the open market to make am I correct?
You're correct.
When
And
I
this-
say that?
And this grant here for these 3 houses, the duplex and the house, is for this disaster grant that they had a couple years ago, the tornado that come through Jackson and done all the damage. It's on,
So it's
on
from
that
the
grant.
Federal Emergency Management Agency? So it's a public money grant?
We don't care how they bid it. Our
We-
board doesn't.
You know, that's the way we operate, like this gentleman here is saying. You know, it's all grant money.
Well, I agree, it's 3 different projects, and I think if he had done 3 different bid packages, we wouldn't have. Hey, don't do it that way again.
Well, we kind of learned, okay?
I would suggest that in the future, you have a separate bid package for every building you're doing,
Okay.
and then you won't have any question at all about it. What was the recommendation then?
My recommendation is for them to just an opportunity to rebid the project. That would be the fair thing to do,
On the two duplexes?
the whole,
House-
the whole
house was-
thing.
The house.
House was a separate
properly
bid
done.
anyway.
He's separate. He's not complaining about the
The
house.
house is properly done. The duplex is the one that we're combined.
Is it gonna cost you all a hardship to have to go through a rebid process? Are you under a time constraint on that?
Beyond the time constraint, we have to have these done by December the 1st. But if we have to do them,
Or
rebid them,
duplexes.
we'll just have to rebid them. You know, we're doing whatever y'all want us to do. That's what we're trying to get this solved with this gentleman.
Everybody knows what their bid, it'd just be simple, to just redo the, everybody just give, just like Bill said, we just have two different contracts,
You're gonna have three different contracts.
three different contracts. You'll have one
And
for the
they're all
house,
gonna
one
be
for
under
duplex,
this
one for
guy's
second
limit.
duplex.
Should they not rebid just the third, actually bid for the first time on the third one? Because they,
I think they need to rebid my personal opinion is the house doesn't need to be rebid.
Right.
I think it was properly done. But because there was a separate bid package for the house, correct?
Right, yes, sir.
But there was only one bid package for both the duplexes, and that's where the problem is.
Like they doubled the,
They doubled the contract amount, and it seems to me that there should have been a separate bid package for each one of those houses. And, but I don't think that the guy that bid is at fault. I don't think he should be penalized.
I make a motion here, and I make a motion then that they go ahead and rebid the project, and we put a letter of warning in the contractor that bid, the low bid for the duplexes. Put a letter of warning about bid limits, licensure limits in his file, or send him a letter of warning. Don't fine him, but send him a letter of warning.
And he's allowed to rebid.
He's allowed to rebid, I think so.
And we're talking about the two duplex projects.
Talking about the two duplexes.
I second that.
Any other discussion? Question, all in favor, say aye.
Aye.
Any opposed?
Oppose.
No.
Roll call vote.
Ronnie?
Aye.
Reese Smith?
No.
Aye.
Jerry Hayes?
Aye.
Mark Rudd?
No.
Bill Mason?
Aye.
Cindy DeBus?
No.
Marvin Sandrell?
Aye.
And Ernest Coleman.
Aye.
Carries. And that's the board.
If this gentleman that got the low bid, why would we give him, why is he getting a letter of warning if he did what he was asked to do?
Because technically, if we, I think, this is my personal opinion, technically, those two units could have been bid as one. You've had a misunderstanding, and because you've had three other contractors bid those two units as one under their license limit, if it was construed to be at the two units together as one bid, it would have been over his license limit, and I just want him to be aware of it. It's nothing that will affect him negatively. It's not going to hurt his credit report. It's not going to be anything. It's just going to be a letter of caution, letter of warning. Don't go over your bid limit. You know,
I just want to make sure I understood. You didn't ask for it to be bid together. You asked for separate bids. The guy did what they asked him to do, and now we're going to put a letter of warning in his file?
But the reality.
That will
And make
affect
him rebid it after he's already showed his hand.
Right, and that will affect him.
If he was advised that way, you're
He didn't
penalizing.
do anything
him.
wrong,
Yeah.
according to,
That's my question.
The other
I mean,
three
he
bidders,
did
though,
what I
saw
asked him
what
to
was
do.
really going on. I mean, they
But
were the
that's
one
not
that
his
actually
fault.
understood the project
Well,
and saw what was going
that's-
on.
It's still
They-
not his fault.
I think, well,
We've already voted.
Yeah, we voted and
Well, there's a way out of the vote.
Yeah.
And I can rescind my motion. And Mr. Chairman, I'll make a motion to rescind my motion if the,
Of the letter
if the
warning.
maker, if the second will rescind the second.
you just want to take out the letter of warning?
We'll redo the motion, or we can
Why don't you just move?
Amend
Letter
it?
of warning. Yeah, just
We can amend the
just-
motion
just
to remove
not
the letter
do the- yeah.
of the warning.
A new motion to not have the letter of warning.
I think first you'd have to have a motion to, and then a vote
and the
to rescind
first
it.
vote. Okay. You agree to rescind, Bill? All in favor of rescinding, say aye.
Aye.
Any opposed? All right, we rescinded that.
Mr. Chairman, now I will make a motion that they rebid the project as two separate projects,
The duplex project.
the duplex projects only. The house is irrelevant.
Second.
Okay, any other discussion? All in favor, say aye.
Aye.
Any opposed? Okay, that motion carries.
Mr. Chairman, can I just say one thing real quick? I want to commend our staff attorney on his or their timeliness. I think we all received our legal report a week, maybe 10 days, 2 weeks ago. I usually get it when I walk in the door. It was accurate, it was on the ball, it saved us an hour, hour and a half, and that's a first, and to be commended so far.
Appreciate that.
Thank you, Benton.
Thank you.
I don't believe we voted on the legal report yet, though, so we need to,
Somebody want to speak?
I'd just like to ask the board to repeat the outcome.
Know what number it was?
201-302.
I mean, the item number.
No, ma'am.
Okay.
201, what?
201-302-44.
Be 2013-01844, is that what? Mm, okay.
Is it in this particular legal report?
Yes, sir, I was told it would.
Two zero one three zero one 8430. Okay.
That, members of the board, that case is actually, that was one that we presented last month that was closed due to a technicality, and then it was reopened in,
Didn't it represent?
it's actually, well, it wasn't in the represents because it was initially closed due to that technicality. It's number 56, and it's case number 2014-013-971. And that was the case that was recommended that a litigation monitoring consent order be assessed in this case. So if the board does adopt that, then it is still open pending the completion of the litigation taking place.
Page 15.
Why does it have a different number on it, case number on it?
The case number that she's referring to was the original case number that was assigned to that case. And last month, or 2 months ago at the previous meeting in Jackson, the board recommended that one be closed due to the technicality of the way in which the complaint was originally filed by the complainant in that case, because it was not actually filed under the complainant's name. And so we had to close that and reopen it under a different number.
It's the same case, a different number.
Right.
And the status now is what?
Now the subcommittee decided that they wanted to assess a litigation monitoring consent order, which basically allows us to monitor any sort of legal action that's taking place in the court system and allows them to keep us updated on what is occurring in the case. And then at the conclusion of litigation, that's when we would normally represent it to the board at that point and let the board make a determination at that point.
That answer your question?
Yes, but can I ask a question?
Sure.
Please come up to the podium, state your name.
There is an issue with this, though, that if we allow them to present information today, this is a matter that may come before the board at a later date, and therefore the entire board may have to recuse itself at that point.
Question you could ask our counsel after the meeting.
I just wanted an explanation of the board's mission.
Carlin, you want to handle
Have a
that?
mission statement?
Our
Can we
mission
further-
is to protect the public and the safety's welfare, and we do this by licensing, making sure contractors are properly, or follow all the requirements before they get a license, and then we also monitor complaints, monitor these professions to as part of protecting the public, and also licensing provides a level playing field for all contractors.
So if there is, your experts suggest that did not take place, the board cannot act on its own to correct those problems. The consumer has to go through other measures, and then y'all will just monitor that, or the board has power to act?
The board, if you're already in litigation, the judge has more power than the board. The judge, if this is a licensed contractor, the judge can revoke the license if it's part of the charges. So this sort of keeps the board from duplicating the same as what's already going on in the court system, if that makes sense. But once the court does their justice, makes a ruling, it comes back to the board, and that's when the board can take action based on anything that the court left out or that's within their jurisdiction. If the court didn't revoke the license or did not penalize him, discipline him for the wrongdoing, then the board can pick up and discipline him based on just the law violations. That's the only thing they can do is take action over what's in the law. They can't do anything like refund money, award judgments, things like that, like you can in a court.
Obtaining a permit for a project from a city or from the Davidson County doesn't have any power to hold accountable the contractor based on what the board rules is law in the state, and a permit is obtained. The board doesn't have any power. The consumer has to pursue litigation to correct problems against what's licensed and permitted.
And Ms. Lazenby, I would recommend that we not answer any further questions at this time, just due to the fact that there could be pending litigation and pending administrative hearings before the board at this point. So, thank you.
Mr. Chairman, I make a motion, we accept the legal report.
Is there a second? Second. Any discussion? All those in favor of accepting the legal report?
Aye.
Aye.
Any opposed? Motion carries. Item on the agenda is petitions for reconsideration/stay.
Benton to take this.
Mr. Chairman, I believe this was a matter that was addressed to the board at one of my earlier meetings. And basically, we received an email from the chief of the litigation section stating that the legal section has requested for the consideration of the board to grant their chairperson the authority to determine whether or not petitions for reconsideration and petitions for stay should be denied or proceed to a hearing. Rule 1360-04-01-.18 specifically states that a multi-member agency can grant such authority to its chair. And they go on to state that they are running into an issue where these matters are filed, and since they must be acted upon within 20 days and required to call emergency telephonic sessions to cover for the board in that case. This would basically just give the board the option of allowing one individual to sit and make a determination about whether the board should consider petitions for reconsideration and petitions for stay, or whether or not they should be denied. So that it's more of the timeliness issue, and it just gives the board, I believe, more options in this case. It's really up for the board to vote on it.
I think that's something they need to do.
I think it just gives them more options as far as how to address these cases when they come before instead of, I believe the other option would be that you'd have to call a quorum of the board in that case, and in this case it just allows one person to come in and make a ruling on it. And I don't know that necessarily has to be the chairperson.
Example of what that would be?
I think if the board made a determination in a case and the one of the parties was not in agreement with it and decided to file a petition for reconsideration with the board, I believe the way that it is now, the quorum would have to meet to rule on it, whereas in this case, you would just have one person that was appointed by the board to make that determination on behalf of the board. So since you have so many members coming from so many different areas of the state, this would allow one person to come in and sit in and hear the petition and make a determination about that. I'm not a litigator, so I'm not familiar with this happening, but it's obviously something that has been on the chief counsel's mind, and therefore I think it's probably something that they feel needs to be addressed by the boards that have multi-member agencies.
I mean, other than like a summary suspension.
Yeah, that may be the only
Yeah.
similar situation.
Now, I made a motion earlier, and it was pointed out to me after we had voted on the motion that I'd probably made a mistake in my motion. And I'm not real comfortable, even as a single person, making a determination without consulting at least a quorum of the board. And I feel like that's why that quorum procedure is set up. And I don't think we need to change it to give the power to one person to make a ruling, because just that quick you can make an error in judgment and make an incorrect decision that could set a precedence that we would probably or possibly pay penalty for in another issue further down the road. So if we're asking to make, are you asking us to make a vote?
Yes. Yes, sir.
Well, the last time we've had a phone conference to do summary suspensions, which I think that there ought to be a quorum for that. No one of us should do that. I'm like, Mark's not sitting over here saying, yeah, I want to do that. So,
Something, an email come from the general counsel, and apparently they had an issue come up with the other boards, and they were sort of surveying, you all might need to do this. And, of course.
is there some reason this can't be done by a phone conference among the board?
To my knowledge, I believe that could be done.
Reason to change what we're already doing?
There would be a notice issue, yes.
Public notice issue.
Correct.
Right, we've done that before.
Necessity, yeah.
That public notice is short.
Mm-hmm.
And I think that the board's done that several times over the years. We're all very cooperative with Carolyn when that need arises. And I think that's the best way to continue to conduct our business, is open and honest and out in front. And if you get one person that comes in, then you just open the board up for legal ramifications that I'm not certain that we need.
And opens our chairman up for individual criticism that he ought not bear.
And it's not just the rule actually allows for the chairman or any person that's appointed by the board. So, but the individual, it would still be one individual.
We don't do anything. We just leave things the way we are, right?
That's correct.
Pleasure of the board at this point.
And I would request a recess for just a moment so the Miss Brown and I can discuss something that just came up.
Vote on that?
No.
All right.
Just
Let's take
say
a
we're-
5-minute break.
I know, but I want.
I'd like to call the meeting back to order. Anything we need to talk about this issue? You were, okay.
That's the one I thought it was.
Next item I have on our agenda is the PSI exam time extended.
Carolyn? Oh.
Carolyn, is there a PSI exam time extended request?
Yes, there's, let's see, it's in your tab, let's see.
Got it fixed underneath titles.
Okay. Get PSI, okay. PSI has requested that we approve with extending the time on the exams. It's only, some of them, it looks like to be 10 minutes and some are 20 minutes. But they say this will fix the problem that they are having, that contractors are able to park on an experimental question and gain more time for the exam. But they're saying that they do have experimental questions that the contractors are not graded on, but they want to just extend the time of the exam to allow for that. So,
Question is, how does a test taker know the experimental question versus non-experimental question?
that just,
They're giving them an extra 20 minutes to do the exam, and then they're going to count
they won't count the experimental questions.
but as time, when they work on the experimental questions, I count that as time against the
Yes.
exam?
Yes, that will be counted then.
Will this problem be corrected?
Yes, they say this will correct the problem.
Okay.
What does parking mean? Parking on?
Oh, just where you just
flag it to go back. So if you don't know the answer to a question, you can flag it. And then at the end, if you have time left, you can go back to the questions you flagged or parked and answer them.
Okay.
That's the question.
Don't know how they got more time, and I don't know how they figured out they got more time. I will work on getting more answers because that.
We're going
issue.
to correct a problem that we don't know exist or existed for one person, and we're not even sure how it's happening.
There a cheating booklet out there somewhere that we don't know anything about?
There must be.
It says, okay, when you get to those experimental questions, park them, and that'll give you an extra 20 minutes. Why are they adding minutes to the test then?
But generally, an experimental question's not marked. You're not supposed to know that's an experimental question. This all sounds bizarre.
It does.
And
I think I
and we
need
don't
to
really
get-
have enough information to
We don't.
extend our time.
And I didn't know what to ask really, but
Maybe you, the chairman can appoint a committee or something, and they can look into it and report back to the board.
do you think maybe we need to go ahead and extend the time, just this small amounts, so that on August 1st, nobody else can park? And then get to find out more. Change our booklet.
I think we ought to go with PSI's recommendation and then ask them to explain to us what the problem is.
We'll leave the times the same in our booklet and our, so the contractor knows this is what they get, and if they get 10, 20 minutes extra.
Oh, there's 30 minutes extra on the BCC.
Well, the more important question might be to ask, why are there experimental questions in the test? Why don't they just remove the experimental questions and resolve the whole issue?
There's science behind having experimental questions in a standardized test.
This is something they're psychometric. Your subject matter experts they looked at these questions.
How long have these times been in effect that are existing?
It's July 2006, since our contract.
Applicants an edge over past applicants?
Ones testing are given an advantage over the past ones.
I didn't ever remember that we got in, we just awarded a contract, and I didn't ever remember approved or disapproved time limits.
Probably didn't. I don't know if it's, yeah. It's just something I brought to you
Special
all.
needs gets more time. And
You can always retake the test, though,
Yeah,
can't
but
they?
don't they have to pay?
Yeah. I don't know, I mean, on the other hand, Mark makes a point, when we contract this company to do the test, we're supposed to trust them to know how to administer. Well, they know more than I do about administering a test.
This will fix the problem. I mean, it's, apparently it is a problem for PSI. Right. Must have happened, it seemed like they mentioned something in California that they're
We're
testing.
just doing administrative cleanup.
No reason to believe that someone less qualified is going to be getting a license now, is there?
Sounds like when you take the test, if you're on an experimental question, the clock stops until you go to the next question. Fix
That
that,
makes sense.
so they're just gonna give people more time. I don't know that we can do anything other than just go along with their recommendation.
Probably nothing the board has to vote on or do. It's just a suggestion.
We don't have to approve it?
Well,
They say, the thing here says they have requested that we approve the extension.
well, I think I asked them, I told them that you all would need to approve it before they did. They asked to do it for August 1st.
Well, what difference is it gonna hurt if we give somebody the extra 20 minutes on the test? I'm all for giving them extra time. Especially if I was taking the test.
I move that we approve the extension of time.
All right, any other discussion on this? All in favor, say aye.
Aye.
Any opposed? Motion carries. All right, we have a reciprocation item on our agenda.
Discussed this a few meetings back, due to the differences in reciprocal agreement with Arkansas and Mississippi. Arkansas State License Board does not have trade exams. They have a business and law exam. But our reciprocal agreement that's been in place with them, I think in the letter said since 1998, what they give us in exchange is they waive the personal interview. They have an extensive reference requirement, and they waive that for Tennessee applicants. They waive the Tennessee Business and Law exam. And the ones like the electricians and the plumbers, those do have trade exams. It's just not with their board. They have separate boards. So the ones that are licensed with the plumbing and electrical that come into our state from Arkansas, they have passed the test, just not with the state that we reciprocate with. But anyway, they have requested that we continue the reciprocal agreement. In exchange, this is what benefits our Tennessee contractors will get. I have a letter, a draft of a letter.
Arkansas contractor, and you have a license in Arkansas to do general construction work. We
Doing it for years, but they base instead of testing, they base theirs on extensive experience and reference requirements.
And don't they require an audited statement, and we're not gonna have to present an audited statement of it?
All the other requirements still would be the same. I got financially.
Why is it being brought up?
You brought it up.
But why?
When you were reviewing files a few months ago, you called and asked for me to put this on the agenda to research, did we really want to reciprocate with states that didn't have the same?
Because it didn't appear to be apples for apples.
Yes.
Because we were getting contractors in primarily from Arkansas that, even though they were licensed, had not taken an exam. But as Carolyn is explaining it to you, they feel like they're giving us a trade-off for the fact that if you or I, as a contractor, wanted to go to Arkansas, we don't have to go through a background check or a reference check. But we've had to take our exam. So seemed to me like there was something that really set me off about that more than more than just this. And been so long now, I can't remember myself either, but
Other one was Mississippi. Mississippi was requiring everybody, in order to reciprocate, they had to have an audited financial statement. So anybody from Tennessee going to apply for a license in Mississippi, they would waive the exam, but you had to get an audited financial statement, or you could take their exam and the audited financial statement would not be required. I've discussed this with them. This was, I believe, an issue where one of the board members from Mississippi had to get an audit from Tennessee, and he assumed everybody had to get an audit. He didn't realize it was just an unlimited license. So I talked to the director, and she took it back to their board, and they agreed that they were no longer required Tennessee contractors to obtain an audit. So,
Ought to be a even
License under
trade-off.
$1.5 million.
so it's now apples and apples.
I think what they require, then we should require with those certain states.
Already require an audited statement for $1.5 million, and now that's what
Even though they required it for under $1.5 million.
They did.
I think we need to leave.
Do we need to vote on Arkansas or Mississippi?
No, you would only need to vote if you did not want to continue the reciprocation agreement.
Formal hearings. Yes, sir.
Well, I requested it, so I'll comment on it
Well-
first.
We skipped the bid protest. Y'all have another bid protest. I know y'all are trying to skirt around
Old
it.
agenda in front of me, I think.
This one, if you look at page 3, the contractor, instead of listing his plumbing and HVAC contractor in the space where it's the same as above, instead of listing CMC and the same contractor and license number for that portion, they just said same as above. So yes, it was same, yeah,
The
same.
number's correct?
Number's
All the
correct,
information above is correct?
Yes.
Is accurate? Okay.
yes. And so, a complaint was, our board, after I gave the opinion, I emailed them opinion that it was my opinion that the bid was acceptable, and it would not be considered a violation. And it said the CMC license classification covers both, and that it's easily understood that that same contractor would be performing both the plumbing and the HVAC. And their attorney for the second low bidder wrote back that this seems to be not the same as how the board's ruled in the past, and he referenced O case from 2005. Now, the O case from 2005, after I discussed this with Mark, and he advised to pull all that information, and I did, and the 2005 case is quite different from this. The contractor exceeded their monetary limit in 2005. And the contractor had they had offered 3 different remedies. One of them was to split it up between several contracts. And of course, that's a violation of the law. The law says you can't do that. They also asked if they could award it to a different subcontractor, and that's also a violation. And then they offered a third, just to have the general contractor furnish the materials to make the plumbing part less than their monetary limit, and that's also a violation of the law. So the case that they've listed does not compare to this case. But, so what you all are looking at is to see if this would be an acceptable bid or not.
The whole basis for the protest is the use of same as above?
Yes.
But the information above is all correct in every way?
Yes.
There's nothing misrepresented?
Nothing.
No difference what?
Difference.
Good information on the second case that this attorney
I looked on the second case for the one referenced in 2010, and that bid protest is where the contractor listed multiple subcontractors. It was almost like they were doing a little bid shopping. They listed 3 here for the electrical, and had them in columns, and then on the plumbing they listed several. It's not the same issue.
Do we need action on this to ratify?
Yes, we do, because they can't really award the bid right now.
I would make a motion that we confirm and ratify our
Second.
Any other discussion? All in favor of the motion, say aye.
Aye.
Any opposed? That motion carries. Formal hearings, I think we were about to start on.
I requested this information because we have missed so many days when we could have had formal hearings and we haven't had any. And I know that we agreed, and I think I was a reluctant agreement, on letting administrative law judges handle some complaints about unlicensed contractors. So I assume that this list that we've been provided of old cases is all of licensed contractors facing the possibility of a formal hearing. Is that correct?
These are both licensed and unlicensed.
Both licensed and unlicensed.
Yeah.
But I was just concerned that we weren't getting these done, and the backlog, and I see the oldest one on here is 1,533 days. That's more than 4 years old. So that, if that's a licensed contractor, he's renewed at least twice, maybe 3 times. When there's a complaint hanging over his head that this board in some legal report decided there needed to be probably a civil penalty or some kind of a penalty assessed. And, the old proverb is justice delayed is justice denied. And for this contractor, 4 years older, and some of these others that are years old, some of them, there's really no consequence because these are not getting disposed of. And I don't think the board's to blame for that, because it's not like we've said, no, we're not going to hear any cases. I mean, we get grousy and sore, but we listen to them when they come up. And so I don't know who worked up this status report here, but it's and there's a list here of 137 cases a month or longer old that need to be heard. And it seems to me that something has to be done to clear out this backlog. and to send the message that when there are complaints, we're doing our job in this department, in this board, to see that there's some resolution to it, some just resolution to it, some consequences for the bad actors, and some vindication from those who've been maybe unjustly, however it works out. So for both people who complain and people who have complaints against them, there needs to be a resolution on this. You can read for yourself. The cases get scheduled, they get continued, they get settled, which is fine. Sometimes what Carolyn tells me is that it'll get time for us to have the hearing, and they come in and say, well, I want to go through that, I'll go ahead and pay the fine. And that kind of serves the same purpose in a way. But they give us some options here, and I'd like to discuss them. They say, one, would the board be okay with staying late if we get more cases maybe stacked up, more cases scheduled. It appears to me if we had 4 or 5 cases scheduled, the likelihood that 2 or 3 of them are going to be resolved or continued before we get started are pretty high. So my answer is that I'd be fine with staying late. Would be agreeable to meet on a date other than the board meeting day to do cases. These are everyone on this board has businesses to take care of, and I know it's hard to take time out to come do these. For me, that would be a yes. And the other one would be allow an ALJ to handle cases which the board can't meet, and my answer on that would be no on licensed contractors for sure. I was always reluctant on turning over the authority of the board to just an ALJ without us anyway. From what Carolyn tells me, that when the ALJs hear those unlicensed cases, it's rare that the defendant turns up to be even heard, and it is most common for the ALJ to agree with what the legal report already said anyway. So I guess I'm okay with that continuing. So that's my feeling about all of this, but I'll open it to the board. We need to do something about clearing out this backlog. And there has to be a message sent that we're going to get the job done on these complaints. And again, I don't think it's because we're not willing to do it. It's just, for some reason they haven't been brought to us. There aren't enough prepared, and I see that they've assigned attorneys to every case now. Looks like they've got a new system, and maybe counsel can talk to us about that. But what do we need to do to resolve this?
I would prefer, for me personally, it just seems like at the end of the day, we are sort of at our wits' end, but I sort of prefer maybe a day in between in the off month, and we crank up 12 of them, and maybe we could split up into 2. I don't know what that does to a quorum, but we can't do that. But start at 8 and have the last one at 5 o'clock, and just one whole day outside of a business meeting. Just me.
We'd already discussed having Memphis, Nashville, or Knoxville, 3 people who were in that area meet there and do these cases. We'd already talked about that, and it never happened.
They have just
Do
3.
you have to have a quorum?
You have to have a quorum.
Well, that's not what we had discussed. We had discussed that having whoever was in the area, 3 or 4 people in that area, would meet with the judge and bring these people in, and we'd go ahead and handle it there at each individual location, so you wouldn't have to drive to Nashville or Knoxville, something like that. But 3 or 4 people in that area would meet and do that. Like somebody from Nashville would have to come down to Memphis or something like that. But Ernest and I are down there, and somebody from Nashville and Jerry. I mean, us 3 could meet and.
I think we've had a little changeover or turnover in the legal department, and I think that's affected a whole lot of it. But the fact of the matter is that we talked about this 2 years ago or longer, and we did talk about coming in one day during the off month and handling the cases, and we've never done it. And we did talk about staying later. Like today, we could have had 2 tomorrow or 3. It depended on the case, but we didn't do it. And they're not getting resolved, and it's not the board's fault. The board's not responsible for scheduling them. And I guess I'm like Bill, I'd like an explanation as to why they're not being scheduled for the board to hear.
And they can't say it's the money, because we got the money here.
I think that's what they're doing. They realize it's a problem, and they're trying to, with the new litigation attorneys that they've hired, so they've got a total of 7 now. And before, our cases were only assigned to certain attorneys, and those attorneys just handle contractor cases. And now what they're doing, they're splitting it up. And so all of the litigation attorneys, like Shalina, she'll handle cosmetology, real estate, in addition to contractor, she'll handle different boards. So she's not just tied to contractors anymore. So, and that's the same with the other 7 litigators. So this is supposed to be in the general counsel that sent the email, and they also sent the breakdown. It said that this is really an experiment, to see if this gets more cases down the pipeline. So that's what we're hoping. And I know they're scheduling them, they've got dates set up for unlicensed cases anyway. So I think, and it takes, 45 days to get one scheduled. You have to give public 30-day notice, things like that. And then the administrative law judge, we only have 36 days of the year that they will commit to, so we have to work around their days. And also, I've been at some formal hearings, and it's not just contractors. It'll be several hearings, the judge will hear the contractors, and then they'll hear the home inspectors and the real estate, it goes on and on, the different, so they're trying something new. So, and you're right, there has been a changeover in the legal department. So maybe this will work. I don't see how it will hurt, but it will definitely, I'm thinking it looks like they're trying to improve.
I don't want it to look like they're trying to improve. I want some cases resolved. And I'd like, I have to wonder why a 4-year-old case is still hanging around. I mean, even under whatever legal counsel we've got working it, that's a long time. And there's just a difference in some of these unlicensed cases of some fly-by-night, somebody without a license, hit and run, not having a license, and we get an ALJ decision against them, and licensed contractors that are getting renewed over and over again while they got complaints hanging over their head. And I will say, I was asked Carolyn today, like the legal report we did today. She tells me that of all of these decisions we made on the legal report, about half of them will go ahead and pay. A certain number of the others are going to be as unlicensed people. And then a certain percentage, I guess a smaller percent, will wind up on this list here that we need to go ahead and be resolving. So I'm fine with stacking them. I am myself, and I can't speak for anybody else on the board. I'm fine with days in between. I think Reese's suggestion about coming in and let's just do a pile of them in a day. If we did 10 or 12 at a time, we'd knock out these pretty quick.
I don't think it's reasonable to say 12 a day.
I think the attorneys would jump off the building, but, because they have to do the same amount, y'all know that, they have to do the same amount of work for the crack as they do.
If we get 4, though, at 4 times a year, that's 16 that we've knocked out. If we add a couple more during our meeting, there's another 12 to 18 or 16 cases, that's 32. And I guess I'm like Bill, the whole point is let's let everybody know that we're willing to, if you'll pass that on up, the board is willing to get cases settled.
Is the problem the scheduling of these things? You have to allow a certain period of time to.
Right, that's the biggest problem.
Settle, then you got a 2-hour gap or a 3-hour gap.
Schedule, I think usually they schedule about 8, and then if some settle, it's too late to get on another one to bring it in, because you have to give notice of hearing and charges and prove service. It's a lot of work. I can't imagine how much work it is on their end, but memorizing the cases to testify, I know pretty soon I'm going to be getting them all mixed up. But they do a lot of work on them, so it's.
Oh, I mean, if you go into traffic court, they tell you to be there at 10 o'clock, and they may not, the judge may or may not get to you till 3 in the afternoon or 4. You still have to be there and wait. So if we stack them, you be here and you wait till your time comes. Yeah, I'm fine. That's like I say, I'm fine with stacking them.
All due respect, it's a little bit more involved than traffic court, getting,
Sure that it is.
all our proof together. But the main thing is the 30-day notice and showing that we've served the respondent. That's the main thing. And I think if you added another day in between the board meeting, that would help significantly. And, there have been a lot of changes. The position was vacant for the litigation attorney for about 6 months, and there's been a lot of turnover. I think with the addition of the new litigators, there's a little bit more staff that will all be handling the cases will also help. So maybe if you gave us the dates on the off months of your availability, we could start setting those for the latter part of the year and next year. And once we had those dates that you would be coming in, there should be nothing that should stop all 7 of us from setting cases. I don't know if we could do, 10, but I don't see there being a problem with doing at least 3 or 4 a day on those off months.
As long as they're not majorly contested.
Right.
We've had cases that have lasted from 8 o'clock in the morning one day through 8 o'clock the next night. It was a nightmare case, but I remember it lasted a long time with many witnesses called and et cetera. And that would be something that I think you as an attorney would know well ahead of time how hard that case is going to be contested. So on that day, we'd only allow for the 1 or maybe for 2. I think that case was a rarity, but it was a tough, long day for us back that time.
Also, keep in mind that we would have to get an ALJ for those dates, but we could certainly request to the Secretary of State and ask that they assign an ALJ to those other dates, because it'd be 6 more per year that they would have to sit with the board on those cases.
Statute requires a quorum,
Yes.
so we can't designate 3 of us to do them in the grand divisions.
I believe it's the board or the ALJ. You can give the authority to the ALJ to hear the cases.
Give authority to a minority of the board to hear a case.
That I don't know.
You don't know? Can you find out?
Sure. I believe it doesn't specify that, but we can find out.
If it is acceptable for us to designate 3 members of the board to meet, there's 3 of us each from each grand division.
I just know that every time a judge, and I don't mean to butt in, but every time a judge opens a trial case with us, they will ask the chairman if there's a quorum present.
You're right. They have asked that, so I assume that is the law, but we can find out for sure if that's the law. It could just be our way of doing it.
Sure, I'll find that out and have Carolyn forward you all the information.
Yes, that the executive director canvassed the board about days that, she can raise a quorum in the off months. But I think Keith or Reese said, then we would do cases in the off months and during our regular meeting time. We could knock some of these off.
I really believe that, with the addition of the other litigators, that you will definitely see a difference in the next 6 months of additional cases. And I completely understand that, there has not been any cases brought before the board, so I wholeheartedly agree.
Taking a day off between the meeting and
Doesn't mean we'd have the 2-day meeting like we thought we were gonna have all the time.
We automatically set aside the second day for formal hearings anyway. That date's always set for, has been for years that.
It's a long time since we've had a formal hearing on
Yeah.
the second day.
So, I mean, you've got that already, if you can get an ALJ the day after the board meeting. Of course, if you just have one hearing, I've told her that to schedule it on the same day of this meeting, like at around 1 o'clock. So y'all could do that and meet at the same time.
We could do one in the afternoon and 2 or 3 the next day. And then on the off months too, if we want to kill our backlog. Seem like there are opportunities day-wise.
Right here, I mean, it's like, in the afternoon, do one, and then or the next day.
And then if we want to do off month in addition to that, we could clear it out pretty quick.
We still might could scrounge up 5 people without the.
Yeah. Off months. I think
The
we.
main thing is just say who can and who can't, and let's go with it.
Don't get sick.
I'll definitely pass that along. And if you have a quorum, then on the off months, that would help too. Provided we do.
There were 35 days when the administrative law judge was available, or?
36 days. For
Oh,
those are
department?
unlicensed contractor cases only. Typically, we get those dates at the end of the calendar year. So we will have 2015 hopefully by December.
Other discussion on formal hearings? Hearing none, we'll move on to 2015 legislation.
Technical difficulties. The department asked for our annual wish list of legislation. This is something I put together. Basically, it's some of the same things we've discussed in the past, and of course, I asked for a means to collect citations. Instead of having formal hearings on unlicensed cases, issue a citation, like a parking ticket, and then if they don't contest it, like many of these do not contest the formal hearing, then we go ahead and go after it just like you would after a formal hearing and collect the penalty, or at least, attempt to. So that is what's on my wish list, of course. And then I talked to the assistant commissioner, who's now the deputy commissioner, about the hiring 10 inspectors. And what he has committed was, instead of hiring 10 contractor inspectors, is maybe go for 3. And then, but he also said, and I told him the issues that we have. We don't have anybody to police the unlicensed activity. We get calls where, they'll say there's unlicensed activity going on at this site, and we don't have an inspector to send out there. So he's committed that anytime I have that, I can immediately bypass not really bypass, I can do a compliance check, and they will assign it to one of their investigators. And so it would get immediate action. And depending on how many of those type cases, they can always hire more investigators. So that's what he has recommended that we do instead of hiring 10 inspectors. The other things are just general issue of, applying the home improvement law statewide. That's something that may be heard again next year. And and merging the LLE and the plumbers with contractors. Right now, the money is separate, so sometimes they go in the red, and we have to go up there and explain why we're in the red. And so that was something they did with home improvement. And of course, the same
Doesn't it
thing.
come under the same statement?
Do what?
Isn't it just like a separate department underneath this department? But it's all on the same financial statement?
Get a
And you still
separate-
get called up there for that?
Yes.
That's ridiculous.
Do you all have any legislation that you want to be presented? This is all I could really come up with.
Are we proposing, or is this something that you're asking that the board not meet in the other grand jurisdictions?
Oh, that's something that was in the past, but it's totally up to you all. That was from our past wish list, but we can continue that.
Change it to may instead of shall, you can still do it, but you have the flexibility if you don't have any applicants from that area. 'Cause
Right.
we're meeting in each grand division for the convenience of the applicants, right?
A lot of times we go and it just means that, we may not have that many applicants in that area,
Fact of the matter is, interviews are not determined by the applicants, but by us anyway. Just
Yeah.
it's easy for me to talk to
Yeah.
him at home, but on the other hand, I mean, there was, I guess, as far as board members are concerned, some board members have to stay overnight here, just like they would in other parts. I don't know that it's gonna make any difference
It's
at
an
all.
increased cost to the state, right, to secure meeting
Yeah, it's
space?
really difficult to secure meeting space out of Middle Tennessee. Even though the law requires us to, we have to get approval, and it's a lot of paperwork. We have to get estimates. We have to show why we can't meet at a state park or a state facility. So it takes a long time to get a place secured when it's out of Middle Tennessee.
This is just an option.
It's an option, but
Our staff and their paperwork has to all travel.
I'm being really old carrying those boxes. I don't know, but Kathy's still young.
Hire
so-
some younger.
I think I think that you're going to run into some resistance from the legislature, though, because, in all the boards in the past, as you know, and there's a accusation
True.
this board is geographically balanced by statute. Some of them that are not are very heavily Nashville-centric, which creates a lot of criticism from the legislators from the other parts of the state, and probably rightly so. But I'm not saying one way or the other about whether or not we should go to East or West. I'm just saying the reality of it is, East and West Tennessee legislators might say, well, here we are again.
Yeah.
Everything has to center around Nashville.
Yeah, that makes sense.
And I think you'll run into some of that.
It probably depends on what the department wants to do anyway. I think maybe that was something they also were going for to cut down on the expense, but that's where it in, plus it had been something in the past, but
Do we want to drop that request, or do we want to maintain it?
drop it.
I like shall to may.
It's-
Well, realistically, if we make it May, we're not going to meet in East and West Tennessee, are we? It's me though, I'm not speaking for anybody but
I
myself.
kind of agree with you, Bill. It's not worth
Yeah,
getting upset about.
but what about the citation? I can't sell anybody on the citation. I've been trying to sell
You
that.
treat it kind of like traffic court?
Yes. Something for non-contested cases, that's all I want.
Why don't you just give all of us the ability to give citations in our area?
Well, I can get you the citations, but you have to have formal hearings for all of them. So I'm trying to get it, we've already got citations, we just need a law that says uncontested citations. You know, if you don't reply, if you don't respond, that means you're guilty. Don't y'all like that idea? Right, guilty until proven innocent, yeah. I mean,
You're talking about unlicensed activity?
unlicensed only. Because most of our formals are uncontested. The last formal we had, no, not the last formal, but the one we had about a month ago, his first statement was, "I'm guilty. You know, I did it, yes." And the judge is shaking her head like, "Why are we here?" Because he was offered a consent order. He was offered everything to settle it. And his first statement was like, yeah.
So failure to respond or contest it would be a default judgment in favor of the state?
Right.
Not requiring a formal hearing? I think
Right.
that's a great idea.
Yes, okay, so I can go with that.
Well, I think that the legal process in this situation, the way the statute is set up, correct me, counsel, if we're wrong, you just can't, they won't let you do that now.
Well, that's whether she's talking about a legislative fix.
I think they'll change it.
Well, they
Got an absolute reason for that, and that's due process. And if you eliminate the due process part of it, then now I may be wrong, but I think that's the purpose behind it.
But due process would be, they've been informed of the violation, they've been given every opportunity to respond, it's just like, there's all kinds of legal and judicial system citations, and if you don't appear, isn't
I'm
that
all
right,
for it.
counsel? It's default in favor of the people, if you just don't appear in court, that's what they've charged you with?
Right, the state would still have to prove their case, but, in order to grant the default
Still have to prove the
judgment.
case, does that mean we have to have a formal hearing?
The way that it's set up right now, I think you obviously have to do that. I'd have to.
No, that's how it
I'd
is
have to look
now.
further, research it further to tell you whether or not that's something that would be allowed.
Put it on legislation?
Yes.
All right. How about a budget update?
Still doing good. We're doing good. LLEs have already started coming in. The majority of them expire in September, so their fees will drastically increase in September. And these are usually a couple of months behind by the time we get the report, so this is May. But, and this is just to give y'all an update, and this was something the Assistant Commissioner asked me to do every meeting, just to show you what we bring in, so. just
This
so
is
y'all have-
income.
Yes.
Doesn't
it-
have-
Why only revenue? Why don't we get the expenses and balances?
I can't give you that. It was just like 500 sheets of paper, but I can do that. I don't get it electronically. I get it in paper form, so.
Really?
I can get y'all the expenses. It would just take 2 more hours out of my day, but that's
No,
okay.
don't do that. I'm just thinking that there should be a budget sheet somewhere that gives you a summary. We used to get it.
Yeah. I'll check with the accountant to see why we can't get it electronically. I'll push for that.
New business.
September 23rd.
September 23rd.
Oh, I can talk to Mark about the hotel later, but I just need some idea on getting it reserved, so.
Tuesday, September 23rd is what I have.
Lena, can they do a formal hearing on the 24th in Knoxville?
Or if we had the ALJ scheduled, which I'm not sure if there is a designated ALJ set for that day, sure. It would just mean that whoever was setting the cases, whatever attorney was setting the cases, had to come to Knoxville, and all of those witnesses as well. So maybe we can look for some cases that are in that area, so they wouldn't have to travel all the way, and I will send an email to the others and let them know that you'll be in Knoxville and would like a case that's in that area. So it'd make it easier on those witnesses.
When will you know if there's an administrative law judge available?
Sorry?
Did you know if there's a law judge available?
Does the board typically have one set? I mean, I'm not familiar with Contractors Board. I know that the Real Estate Board has it already preset for the day. Do you know, Carolyn?
No, as far as the ALJ dates, no, we don't have a list of those.
You have one automatically set for the second day of the contractor?
The board does.
Okay, then it's probably already set, and we just have to confirm with the Secretary of State's office to make sure that there is a ALJ in Knoxville.
I'm fine with hearing cases that aren't in Knoxville. Let's get some cases that we can hear. All right. Anybody want to adjourn?
I like the scheduling you put together, Mr. Chairman, for today.
Kicking and screaming, but he did it.
I guess it was the 10:30 lunch that did it.
Yeah.
All right.
You're the one that's got.
You won't be in Knoxville.